Good afternoon, and welcome to the Gruber Distinguished Lecture on Women's Rights at the Yale Law School. Today, we mark the first Gruber Lecture of this academic year, and we're fortunate to have with us a lecturer who, in a very short period of time, managed to change the world a whole lot for the better. I will introduce her in a moment, but first I want to say a few words about the two people who made this lecture possible. In 2011, Patricia and Peter Gruber created the Gruber Program for Global Justice and Women's Rights at the Yale Law School, this law school. It is a force for education and for social change. It assists judges from around the world in understanding issues of comparative constitutional law. It encourages the work of graduates of Yale University who go out into the world to make it a better place. It supports effective clinical programming, and it brings us lectures like the one we are privileged to hear today. We are honored to have Pat Gruber here with us this afternoon, and we miss Peter Gruber, who passed away a little more than a year ago. Together, their passion for justice and their foresight in creating programming to educate and empower future activists and policymakers is what makes today's event possible. And we are very grateful that they have chosen Yale Law School as the vehicle for your vision. Thank you, Pat. Each year, we host two Gruber lectures. This spring, we're going to hear from Alexander Elenikov as the Gruber Global Justice Lecturer. Alex, who is a graduate of this school, is a deep scholar of immigration law, and he has just stepped down from his position as Deputy High Commissioner of UNHCR, which is the UN's refugee agency. But now, today, we welcome with anticipation the Gruber Distinguished Lecturer in Women's Rights. Our lecturer is also a graduate of this law school, Catherine Lhamon. Unlike Alex, Catherine remains in her government position, and so we must respect the limits that she is obliged to observe of what she can and cannot say. Catherine Lhamon is presently the Assistant Secretary for Civil Rights at the United States Department of Education. In that role, she enforces some of the most important anti-discrimination laws on the federal books, among them Title VI and Title IX. We are very privileged to hear her talk today on women's civil rights and education, building on our legacy, delivering for our future. 20 years ago, in a book review published in the Yale Law Journal, Catherine Lhamon asked us to understand the causes of, and I'm quoting her now, the socially and legally inequitable treatment of women. And she asked us to understand this, quote, with intersectional analyses that make vivid how questions of gender interact with complex questions of race and of class. And in retrospect, it is plain enough that these inquiries have all along propelled Catherine Lhamon's remarkable career. After graduating from this law school as a prize-winning student, and after a clerkship on the Ninth Circuit, Lhamon spent the first decade and a half of her career as a public interest lawyer, beginning at the ACLU of Southern California. There she litigated a breathtaking array of issues, from the fight to secure farm workers' rights to the effort to end discrimination against Section 8 voucher recipients. But I think it's fair to say that education has always held a central place in her imagination. Education is, after all, the crucible in which we forge our future, and Lhamon has always been alert to the importance of building a better future. Thus, as a young ACLU lawyer, she worked to hold California liable for its failure to provide decent facilities, materials, and teachers for low-income students. She alleged that this failure constituted a violation of the Equal Protection Clause of the state of California. And the resulting case, Williams versus California, was truly an epic victory. It set new standards for what constitutes adequate supply and upkeep of schools under California law. And soon Lhamon was appointed director of the ACLU's Racial Justice Program, and in that role, she represented the plaintiffs in Cantrell versus Granholm, a challenge to Michigan's ban on affirmative action. After serving with distinction at the ACLU, Lhamon moved in 2009 to America's largest pro bono law firm, Public Counsel, to establish and direct its impact litigation program. And there, she brought the far-reaching case of Reed versus California to end the practice of the Los Angeles school system of handing out reduction in forces notices in reverse order of seniority. The problem, as Lhamon and her team saw it, was the difficulty of getting teachers to remain and acquire seniority at the poorest schools. In Reed, more than half of the teaching staff of the 3 plaintiff schools had lost their permanent teaching jobs in 2009 as a result of budget layoffs. And the use of seniority to determine layoffs without even considering variables like, for example, the quality of education, had a disparate impact on already disadvantaged students. Hence, Lhamon argued, it violated the right to equal protection of the laws. Lhamon and her team filed suit in February 2010, and less than a year later, a California Superior Court judge approved an extraordinary settlement. The state agreed to identify and protect from staff cuts 45 schools every year, schools that had struggled with teacher retention or that would be most adversely affected by loss of staff. The outcome angered the city's powerful teachers' union, but Lhamon has never been intimidated by the anger of those who stand in the way of educational equality. In 2013, Lhamon moved to her present role as Assistant Secretary for Civil Rights at the United States Department of Education, and she has been at the center of fierce controversy ever since, and she has never backed down. The range of her portfolio is staggering. She deals with everything from Title VI and race discrimination to issues of disability and accommodation, to charter schools, to the effects of school discipline, to the relationship between sex segregation and the single-sex education that was so favored by the Bush administration. And just this past July, her office informed a school district in Virginia that its refusal to let a transgender student use the bathroom corresponding to that student's identity of choice constituted sex discrimination under Title IX. And of course, I haven't even yet mentioned the issue of the relationship among sex equality, Title IX, and gender-based violence, an issue that is palpable on this campus and that probably has motivated many of you to attend this lecture. On this volatile problem, let me say only that Lhamon has exerted tremendous influence. Indeed, Lhamon has handled all the many controversial issues of her office with grace, despite being under all but unbearable pressure. The docket of the Office of Civil Rights has exploded, literally doubling in the past 7 years, even as the Congress has slashed its budget and the number of its employees. Lhamon has responded by, for the first time, making the dockets and the decisions of DOE transparent in the hope, as she testified to Congress with I thought, a kind of wicked sense of humor. She testified, quote, that this increased transparency spurs community dialogue and serves as, quote, an important enforcement tool, raising public awareness regarding the issues and prompting action at additional schools to achieve fuller compliance with the laws. As she said of her office to the Washington Post last March, quote, we have the trust of the national community bringing to us their deepest hurts and asking for resolution. So we are honored to welcome Catherine Lhamon back to Yale Law School today to discuss the challenges and aspirations of women's civil rights in education. After Assistant Secretary Lhamon's remarks, she will be joined in the conversation by 2 distinguished leaders in the field of gender justice, both, like Assistant Secretary Lhamon, alumna of this law school, Dean Michelle Anderson and Judge Nancy Gertner. Over here. Michelle Anderson is the Dean of CUNY Law School and one of this country's most prolific and insightful scholars on the law of sexual violence. Her work on the legal definition of rape has helped spur conversations about whether a lack of negotiated consent should serve as the standard for sexual assault. And I'm very pleased to say that next semester, she will return here to teach a course on gender-based violence as a Peter and Patricia Gruber Fellow in Women's Rights. Judge Nancy Gertner served in the United States District Court for the District of Massachusetts from 1994 to 2011, before leaving her courtroom for the lecture halls of Harvard Law School. As a path-breaking litigator in the 1970s, she fought overt and covert sexism in all its forms, chronicling her many battles in her outstanding 2011 autobiography entitled In Defense of Women, Memoirs of an Unrepentant Advocate. Nancy taught at Yale for many years while a judge, and she now attends the Global Constitutionalism Seminar, which is sponsored by the Gruber Program. We are also lucky to have with us today Professor Drew Days to moderate this conversation. Drew, who needs no introduction in this audience, is, as you all know, a former Solicitor General, a beloved teacher, and an influential thinker on questions of civil rights. And I should say to you, just a week ago, he won the American Lawyer 2015 Lifetime Achievement Award. I understand that Drew made very special efforts to be with us here today because it's his granddaughter's birthday in Texas. And so I want to take this opportunity to wish Georgia a happy birthday, 4th birthday. And I hope you relay to the entire Days family our thankfulness for allowing you to do this. Thank you so much. So immediately following the panel discussion, I invite all of you to a reception in the dining room where I hope we can continue this conversation. And now join me in welcoming this year Gruber Distinguished Lecturer in Women's Rights, Catherine Lane.
So thank you very much for that generous and very lovely introduction. I think no one other than you and my mother and Reva Siegel, when I was writing it, have read that article from 20 years ago. So thank you for dredging it up again, and thank you again very much for the introduction. Also, thank you so much to the Gruber program for having me. It's lovely to be home at Yale, and wonderful to be back here with all of you. I loved my time here. I did, as those of you who are students here now do, learn with giants here at this law school. It's amazing to have the opportunities that you have, that I had. Reva Siegel taught me sex discrimination and frankly everything else when I was here. Drew Days taught me inspiration. He wasn't here when I was here. He was on leave in the Clinton administration. But we were so excited about what you were doing for country and for me. So thank you for it, and it's lovely to be back with you. And Burke Marshall was my small group constitutional law professor, and he was and is my hero. He wrote the 1964 Civil Rights Act, which I now enforce. He was Assistant Attorney General for Civil Rights in the Kennedy administration, and it is his guide that I try very hard to follow in the work that I do now. So I learned here how to fight the good fight well armed, and I'm really, really grateful for having had that opportunity, and I want to spend my time now talking about what it is to fight that good fight and what I think a vibrant civil rights enforcement agency should look like, and what I think we need to be doing. So I want to situate us in context as we talk about today women's rights, women's equality. It's important, I think, to notice how far we've come and the tremendous gains we've made as a country, and the crying need for us to do more still, because we are so far from where we need to be. All women have race and national origin. All women have ability status. So I'm going to situate our conversation in all of the civil rights work that I do. And I want to start with the both and premise of how far we've come and how much more we still need to do. Brown versus Board of Education was decided the year that my mother turned 10 years old. And she attended racially segregated schools. She is black. As a little black girl in Richmond, Virginia, both before and after Brown versus Board of Education was decided. She rode the back of the bus. She drank from colored water fountains. She couldn't try on a hat in a department store. And Brown didn't change those circumstances or her schooling circumstances ever in her lifetime. But it did dramatically change her expectations about what this country would mean for her, what was possible for her, and the fact that the highest court in the land had said that the circumstances of her lived experience are unconstitutional and would be changed and would not be what would be her children's experience was incredibly meaningful for her at 10 years old, was incredibly meaningful for her ever after, and was a theme to which she raised me, and is a theme that I grew up with in my life. My brother and I, when we started school, integrated a white flight school, so I had a different version of what she lived, materially different version of what she lived, but nonetheless a version. And even all through high school, when I was no longer in the South, when I had moved to California, I went to school that was integrating because a court ordered it to integrate. And so I lived the legacy that had been my mother's legacy. And my life is and was much better than my mother's is and was. And my kids' lives are, and I hope will be, much better than mine are. My two daughters grow up with my ability to say to them what my mother could only hope would be true when she said to me, "You can be anybody you want to be." My daughters see that, they believe that, they're living that. My brother and I grew up with our whole consciousness in the promise of civil rights. The Title IX is 1 year younger than I am. The Americans with Disabilities Act is my brother's life. My brother has cerebral palsy. My brother was able to attend school where there was a right for him to be able to physically access the school buildings all of his life. That was not true for the generation that came before. I get to raise my daughters in the expectation that girls play here at school because we have a national consensus that we have to respect the interests and abilities of our girls in school. So we are in such a different place than my mother was, than I was, and that forward movement requires vigilance. It requires ongoing commitment to cement the gains we have made, to imagine the ways that we will want to dial back on those gains and to get ahead of them. So I think we need to own the creativity of our past, recognize how far we've come, and insist that we have farther still to go and that we can get there and that it's worth it. So that's what I want to talk about today. I think that we have seen unbelievable gains over time and that we haven't imagined all of the gains that we ought to be able to make. And two key areas in which we had really not made very much progress at all until this administration are the area of sexual violence and the area of school discipline and equal access to school opportunities. So I want to talk about those two and several others today as we think about where we are, but also noting how long it's taking us to get there. So sexual violence, I appreciate the recognition that we've seen a sea change in the last few years, and I think that, and I agree. And Title IX became law in 1972. We issued regulations in 1975 that said that schools needed to have policies that required prompt and equitable responses to sex discrimination that came to them. It's been a long time coming for us to get to this place where we say no more. And it's time. It's really, really past time. Likewise, with respect to school discipline, the very first desegregation agreements that my office started enforcing in the 1960s all included school discipline as an element of the desegregative steps that districts needed to take. They included it because we were overly segregating, overly disciplining our black boys and girls in their schools, and we knew we needed to change it 50 years ago. And still, we're having a conversation about the school-to-prison pipeline in this administration as if that's a new concept. And still, our data shows that our black youth are 3 times more likely than their white peers to be suspended or expelled from school. And our investigations reveal that that data is matched with discriminatory intent as well as discriminatory impact. So we know we need to do better. It's well past time for us to do better. And as excited as I am about what we are doing better in these areas, it's not enough. And we need to be working for what else we can do and how else we can get there. So I'm going to turn to sexual violence and start there. As I think probably many of you know, we issued guidance in 2011 that called out sexual violence as a civil rights issue. That was the first time any administration had ever done that. It was incredibly important to do it. But it was very far from the first time that we had been enforcing in the topic, very far from the first time that we had talked about the topic in guidance. We had put out guidance in 1997 about sexual harassment. We had put out guidance again in 2001 about sexual harassment. That guidance called out sexual harassment, of which sexual violence is a species, as a civil rights violation, said the kinds of things that we wanted to see schools do to correct that violation, and explained the way that we would enforce. And then we did enforce, but we did it quietly. And so it took until this administration to say in 2011, look, this is an issue that we're serious about. We really do have expectations for what it is we want to see our schools do, and this is the way that we will enforce if we come and find you. And then to follow that, after we had lots and lots of questions, after we put out that guidance in 2011, with another Q&A document in 2014 about what we would do. We expected when we issued the guidance that we would see an increase in the complaints that would come to us, because that's pretty common for us. When we put out guidance, we see an increase because people know that we're there, they're thinking about the topic, and so we see some more. We didn't expect a 760% increase in the volume of complaints that came to us, which is what we did receive with respect to complaints related to sexual violence in institutions of higher education. I want to concretize that because it's an enormous number, but it means that in 2009, when this administration began, we received 9 complaints about sexual violence in institutions of higher education, and in 2015, we received 152. So the numbers increased enormously, and they're not that many in the scheme of what we actually receive in general. We have 10,000 complaints that come to our office a year across all of the jurisdictions that we enforce. We tend to have 4,000 investigations open at any given time. So as much as the sexual violence investigations have increased enormously, and the complaints have increased enormously, they are a tiny subset. They are less than 10% of the total volume of the work that my office does. But they are an outsized component of the public's knowledge of what we do and conversation about it. So I take the increase in complaints that come to us not to mean that there are more incidents of sexual violence taking place on campuses, but to mean that more people know that we are here, that we're open for business, that we're serious about the topic, and that we will investigate if someone brings a complaint to us. So I think that we need to work hard to honor that trust that people are bringing to us and make sure that we are doing that work as well as we can. So I want to tell you some examples of our recent enforcement work in the area of sexual violence to situate what it is that we're doing. And one most recent example comes from the University of Virginia, where we entered into a resolution agreement in September. The University of Virginia now operates with a totally compliant with Title IX policy, which is very exciting. That's the first university about which we've said that the policy is fully compliant. And I am very, very excited that the university now has a policy, especially because until last March, they had a shockingly non-compliant policy with respect to sexual violence. That policy until last March, I'm going to tell you about for lots of reasons, partly because it is jaw-dropping to me, but also because we are often accused these days of not taking into account the rights of the accused and of tipping the scales too far in the direction of accusers. I take that charge very seriously. It bears no relationship to what we've said in our guidance. It bears no relationship to what we do in our enforcement work. And I think it's very important for our message to be consistent that we want all people's rights to be respected at school. And our guidance has been that schools need to have policies that are prompt and effective, and that they are fair to all students. The UVA policy until March had been that if students wanted to use what they call their informal resolution process, then the accused student and the accuser could come together and talk about their feelings about what had happened with somebody at the school who would moderate. And categorically, the school would not investigate. That was a prerequisite to using the informal resolution process. The school would not investigate, but if the accused student, in the course of this discussion about their feelings, admitted responsibility, which you will note is not an unconstrained option for the accused student, but if the accused student admitted responsibility, then the school could impose a penalty. We learned in our investigation that even when the student didn't admit responsibility, the school nonetheless imposed a penalty without investigating, which is astonishingly unfair both to the accused student and to the accuser, because you can't know what would be an appropriate penalty if you haven't investigated, because you can't know if it happened, and you can't know what happened, what the it is, and what would be responsive to the injury. Worse, if either of the students didn't like the penalty that the school imposed without having investigated, they could appeal, and a hearing board, again without investigating, would impose a penalty. So it's, I think, the definition of a kangaroo court that they were operating, and we called that out. We said that's not acceptable. That has changed, and if they will change their policy during the at least 3 years that we will be monitoring them in the course of the agreement, they have to seek our approval in advance before they can change their policy going forward. So they now have a fair process, which is good news, but it took until this school year to get to a place where they will operate a policy that is fully rights protective for all people involved in it. And as you may know, that's a school that has undergone some notoriety on the topic as well. So it took a little while to get there for them, but I am glad that they are there now. Just before we entered into the resolution agreement with the University of Virginia, we entered into a resolution agreement with Michigan State University, which has 50,000 students. So I'm very excited about it for numerosity alone, in addition to what else we achieved at the university. This is also a place where we needed to speak to the rights of the accused as well as the rights of the accuser. This is a university that had been training its students about sexual violence in ways that didn't even recognize the possibility of non-heterosexual sexual intercourse, and also didn't recognize the responsibility or the potential for responsibility for women in heterosexual incidents. So that has changed, and they do now. We also learned in the course of the investigation at Michigan State that they had operated a counseling center where one of the counselors was counseling students who came forward to talk about incidents of sexual harassment and sexual violence, was sexually harassing the students who came forward for counseling. And the school knew about it in 2009 because a student complained. The school's response in 2009 was to have the allegedly harassing counselor sit down with the student who complained, which was a surprise to her, to talk about what she thought had happened. And then to keep that counselor employed until 2013, while students were still complaining, still saying that they're coming forward and saying that they've been sexually harassed and that counselor was harassing them, but the school wasn't taking action. So that was among the more jaw-dropping facts that we have found in our investigations, and also among the more disturbing. He's not employed there anymore. They now have a policy that we are excited about for the school, and they have undergone training and have entered into an agreement that I think is very, very, very strong. And they, like UVA, have leadership who are committed to this issue moving forward and to moving their campuses forward in ways I'm very excited about. I'm going to tell you just one more higher ed sexual violence investigation example before turning the topic. This one is from Southern Methodist University, and this case illustrates why it is, for me, illustrates why it is that schools need to be involved in this topic. I'm often hearing when I give talks that maybe campuses shouldn't be involved, and maybe this is a role only for the criminal justice system because it's just really hard for our campuses to be involved. Well, Southern Methodist University came to us through 3 complaints. One of them was from a man who alleged that he had been raped on campus by another man. And he went and reported to the school and said he needed help. The school said, this is a criminal matter, you should go to the police. He did. The police arrested and indicted his attacker. And then he went back to the school, and the school said, great, really happy that the criminal justice system is working as it should. This is now a police matter, and we don't have a role, which I'll stop by saying that that's a Title IX violation. But in addition, what then happened to this student illustrates why the school did have a role. What then happened to the student was that the friends of the man that he had accused harassed the student. They came into his dorm room late at night, they knocked on his door, they called his room, they were catcalling him, they outed him as the person who had complained, they harassed him across the cafeteria and the dining hall. And he went to his school and he said that he was being harassed. He said that he didn't feel safe. He said that it had become uncomfortable, and the school said, you need to go to the police. We know in this room that those are not things that the police can address, that those are not things that the criminal justice system is equipped to deal with, but they are things that the school should have dealt with, and it now will, because they now understand that he had a right to expect that his school would respond to the sexual harassment that was taking place for him, and that he had a right to continue learning in the environment that he had chosen. The ugliest thing about this story is that he dropped out of that school. So that was his dream, to go to that college. That's where he wanted to be. And he didn't get to be there because he got raped and then his school wasn't there for him. He didn't get to be there because his school didn't understand their responsibility to make sure that they had operated a safe learning environment for all of the students. And I am devastated about that. I carry that with me every day, that student and that other students don't get to learn in the environments that they chose and the schools that chose them, because the schools haven't found ways to make sure that they're environments that are safe for all of their students. As much as we know that these and other stories take place on our college campuses today, we also need to know and to recognize that sexual violence does not begin when you turn 18. It doesn't begin when you go to college. There are kids who are being subject to sexual violence and sexual harassment in elementary school, in middle school, and in high school. And we don't talk enough about that as a country, but I see it in the investigations that come to my office. So I want to tell you some of those stories as well. One of them was from a school district in California where we had read about a very notorious gang rape that took place on campus when a young woman was coming home from her homecoming dance. She was gang raped on campus for 2.5 hours on her campus. We hoped when we opened that investigation that that was an aberration and that we could investigate, figure out what had happened, and maybe share some best practices with the district to move forward. We learned instead that multiple middle school students were raped in that district that same year. And we learned in that investigation that on the middle school campuses, of which there were many, this is a large district, there were whole swaths of campus where kids would say, well, they just wouldn't walk on that part of the campus because they would so regularly be groped if they went there. They were so regularly catcalled. They were so regularly having names called at them. And their administrators in these campuses in this district confirmed that. They knew it. They saw that it was happening. They understood that the harassment was taking place. And what they said to us, this is a heavily Latino district, what they said to us was, well, that's their urban culture. Not very coded, that language, about the expectations for the adults of the kids. That's how kids are. That's our urban culture. I have a daughter who started middle school this year. That is not the culture of her middle school. It is not acceptable to me as a parent for her, and that is not acceptable to me as a parent for anybody's daughter in school. That is not what should be happening in our middle schools, and that the administrators in that district thought, you know, that's how kids are. That's how these kids are today. Is a lesson that they have now learned is not true. And one component of the resolution agreement, about which I'm very excited, is that that district agreed to bring the community in to talk about what they want in their schools, to talk about what it would take to create an inclusive environment that is respectful of all of the students, because the district clearly needed some instruction about what it is that we ought to be able to expect for kids in school. Can you not hear me? I'm sorry, I'll speak more. That district is very far from alone. Another extreme story of that type that I'll tell you is from a Texas school district where a young woman was raped in her band room, and she went to her band teacher to tell him that she was raped and that she needed help. And the school disciplined her for lewd conduct, for having had sex at school. And she and her mother went to the school and said she was raped. She didn't want that to happen. She came asking for help. You cannot be serious. And they absolutely wouldn't change their discipline for her. The consequence to her of having come forward was that she saw her attacker more often than she would have seen him had she not come forward, because the school made her and her attacker go to an alternative site where she sat with him in class every day. And it wasn't until we came to investigate and then enforce that the district realized the error of its ways and that they couldn't do that. They are now paying for counseling for her. They have undergone training. They have a new policy. They are responsive to us about what it is that they need to do differently going forward. She has said publicly that our resolution agreement restored her faith in humanity. But what happened to her shakes my faith in humanity. We are too far in this century to be blaming our girls for what happens to them when they are attacked. We know better. That district should have known better. There is no excuse for treating people who come forward and talk about what happens to them as if they are responsible for that harm and visiting further harm on them. In a similar vein, but not quite that one, a district in Indiana entered into a resolution agreement with us this year after an investigation confirmed what students said to us, which was that a volleyball coach in this district, who was an adult man, entered into a sexual relationship with a 14-year-old freshman, which is, to be clear, statutory rape. And when the other girls on the volleyball team complained, it was a pretty open and notorious relationship, and they complained about what was happening and the sexualized comments that he made to that girl and to other girls on the team. They lost playing time for complaining. And then ultimately the district decided that they probably shouldn't have him continue to be the coach for the volleyball team. So they replaced him with his wife because they couldn't find anybody else to coach that team of girls in the district. And so those girls who had complained continued not to get playing time because it was uncomfortable for his wife. He's now serving 21 years in jail for statutory rape, which is good news from the perspective of responsiveness. But the district had to be told, and it was a fight, had to be told that that's not enough, that they actually had to communicate to the other girls on the team, to the other girls in the school, that that's not acceptable on that campus, and that's not acceptable in that district, and to take steps to end the hostile environment that had been created, and to be clear about what their expectations would be going forward for students and their interactions with their coaches and their faculty. So they now have had that, but again, with how far it is in our history that we should have come and the distance we have yet to travel. Because these resolution agreements, these investigations are not the distance past. I'm telling you our most recent ones. I'm telling you what is still happening in our schools today. The sexual violence issue is obviously very important to me. I take it important to many of you who came, but it is very far from the only form of sex discrimination that we continue to see in schools. You may also have heard recently about a letter that we sent to an Illinois school district that is not allowing a transgender girl to use its locker room. And we've said that that violates Title IX, that also constitutes sex discrimination. It's an especially convoluted analysis for this district. They allow this girl to use the girls' bathrooms at school. They call her by female pronouns. They recognize her as a girl in their computer system, but they won't let her in the locker room. And their explanations are that they're concerned about students' privacy, even though this girl has said she has no desire to change in front of the other students and that she would use a private space if the district would make one available to her. So stay tuned. I'm staying tuned for how we will see this one end, but we have been clear multiple times now about the degree to which Title IX extends to protect all expressions of sex discrimination. The transgender issue that has come up in this district, among actually many others that we see around the country, is one species of policing of gender identity that we see in schools. It is unfortunately not the only species of it. We also entered into a resolution agreement this last school year with a very rural Pennsylvania district. This district has fewer than 2,000 students in the entire district. And in this district, an openly gay student's mother had come to us to complain that he had been called gay, he'd been called faggot, he'd been attacked in class, that he'd been called pansy, he'd drawn a self-portrait in his art class and somebody scrawled faggot across the portrait, and they went to the school, and the school said he should toughen up. The school didn't think that they had responsibility to make sure that he was safe and that he could learn for who he is in his district and continue in the school. They now do. He is safe. He's doing just fine. But that policing of gender performance is an all too frequent occurrence still in our schools, and yet there's more. We also see it with respect to our pregnant students and whom they should be and what is appropriate for them and for their learning opportunities. With the Colorado district, in an investigation that we had, we learned that they assigned all of their pregnant students and their English learners and their students with, quote, verified emotional problems. Pause there. I don't know what that means, but I'm pretty sure that if you have a verified emotional problem, you should have a teacher, as you should if you're any other student. But the pregnant students, the English learners, and the students with verified emotional problems in this district had to go to a learning lab where there was no teacher, because that's how the district thought it would be best to instruct those students. They no longer think that those kids have teachers, and they recognize that they need to serve all of their students for who they are. But lest you think that that's an outlier in Colorado and that pregnancy discrimination doesn't take place anymore for anyone else, I want to tell you a story that I really did find jaw-dropping from Virginia Military Institute from when I first started, which is now just 2 years ago. So this is a relatively recent resolution also. But you might not find it shocking that Virginia Military Institute isn't a wildly welcoming place for women in the school. So I was prepared to hear that it might not be the most comfortable place. And consistent with that, we found, for example, that a senior cadet had handed out to the more junior female cadets wire hangers and called them abortion tools for them as a way of making them feel welcome at the school. And the school didn't think that that was an issue that the school needed to involve the Title IX coordinator in. They should have. But they also, worse, at this school, had a policy that if you became a parent, which they defined as at conception, you had to separate from the school or abort. Now, that theory is that it's inconsistent with their moral values to become a parent while in school, because you can't be married and be a student at VMI, and so you're by definition loose if you become a parent in an unmarried state while at VMI, and so you can't be there. But it was enforced in the breach because there were men, students, who crossed the graduation stage holding their children's hands, but women who became pregnant and was visible and you could tell had to either separate from school or abort the fetus. So they don't do that anymore also, which is why I'm telling you the story. But it is also another instantiation of the ways that we have not come far enough with respect to sex discrimination in our schools. I mentioned at the beginning of the talk that I also wanted to talk about school discipline, and also that sex discrimination is very, very far from the majority of the work that we do. I mentioned the number of sexual violence complaints that we received in 2015. We now have 146 institutions of higher education under investigation related to sexual violence. We have more than 400 school discipline investigations open around the country. So a much higher volume of our work has to do with racial discrimination in instantiation of school discipline. Contrary to stereotype, that issue takes place for our girls as well as for our boys, as was made painfully clear 2 weeks ago by the video that went viral from South Carolina of a school police officer picking up a girl with her chair and throwing her across the classroom. So that demonstrates the ugly disciplinary practices that happen to girls in our schools as well as to boys, but it was not an outlier. As just one other example, last January, another video circulated, this one from Baltimore, showing a school police officer grabbing a girl by the hair and slamming her into the wall, and then attacking that girl and her sister and her cousin, who are ages 11, 13, and 14, first with fists, then with baton, and then with pepper spray, even though 2 of the girls being attacked were restrained by school staff members. And counsel for one of those girls has said that the precipitating event for that violence was that a girl walked past the police officer when summoned by the police officer. So that level of aggression has no place in school. None. No place for any precipitating event, and certainly not for walking by when you're told to come to account by the officer. And yet we know that it takes place all too often. We know from the data that my office collects that Black girls are suspended at higher rates than girls of any other race, and than most boys, with the exception of Black boys and Latino boys. We know that nearly 1 in 5 girls of color with disabilities receives an out-of-school suspension. So here's what we do about it. We issued guidance together with the Department of Justice a year ago in January that sets out what the law is, how we enforce, what we expect, and what can be done instead to make sure that our students are learning in class as they should. And we enforce aggressively together with that guidance, which I'm sure is not a surprise, but I'm going to tell you some stories anyway. One is from the Minneapolis Public School District, which we investigated because we were learning that Black students were considerably overrepresented in every form of school discipline meted out in that district. So in-school suspensions, out-of-school suspensions, administrative transfers, referrals to law enforcement, Saturday school, detention, and community service, every form. Black students were considerably overrepresented. When we looked underneath the data and we asked the school staff to explain to us the disparities in the way that students were being treated, in more than a fourth of the disciplinary incidents that targeted students of color, interviews with the school staff could not explain what the differences were in why those students were treated the way that they were. I'm going to tell you just one of the types of difference that we saw. We saw a Black second grade student suspended for 1 day for poking another student with a pencil at school, which is suboptimal. But a white second grade student who threw a rock and hit another student and broke the teacher's sunglasses and hit the other student in the head. That white second grader was allowed to come in at lunchtime and help the teacher to work off the cost of breaking the sunglasses and was not suspended. So that district has entered into a resolution agreement with us so that they will not continue those practices, so that they have a mechanism for looking at the forest and the trees for when they're going to implement school discipline and to make sure that they have fair instantiation of discipline when they do need to implement it going forward. We had a resolution agreement early in the life of this administration, so I can now tell you about what success in implementation looks like. This is with the Oakland Unified School District in California. And one term of that resolution agreement was that the district would assign counselors to 350 youth who were returning to the district from the criminal justice system to help those youth figure out what it would take to be appropriate in school, what are the right classes to take, how it is that they can fully participate in their school communities. 76% of those kids who had a counselor assigned to them did not recidivate. 76%. Unbelievably effective way of keeping the kids in school, making sure that they know that they're welcomed and that the school is there to serve them and that they can be appropriate learners and participate in school going forward. So one thing that I think we don't talk enough about when we talk about school discipline and what it means for our kids is the cost it has for student learning. That when you suspend a kid, when you expel a kid, this kid is not learning. That's time away from school. So what we're saying is we don't welcome you, we don't believe in you, we're not prepared for you, and we don't plan to educate you. And kids get that message. They're very clear about it. What we're also saying is we're just not preparing our schools for you. We say that in ways that are unrelated to discipline as well. And we say that in the opportunities we make available to our kids for high rigor courses. We say that in the ways that we track our kids and where we push them in school. So I want to tell you a couple of examples of the ways that we keep our kids of color away from high rigor learning opportunities that they absolutely would benefit from, would succeed in if we gave them to them. We entered into a resolution agreement with a rural Alabama school district now 2 years ago. That district had achieved unitary status, which is, I hope most of you know, means that they had convinced a court that they no longer segregated students and that they offered equal learning opportunities. This is a district that has about 23% Black students, and they had 4 high schools, but one of their high schools was more than 90% Black students. And that high school had not, until 3 years before the resolution agreement, ever offered a single advanced placement course in that high school. Never, not one. And it's not like they were, they had an international baccalaureate program instead, or they were offering dual enrollment. They just weren't offering high rigor courses in this high school. And we asked the principal why they weren't. By the way, when they offered their first advanced placement course 3 years before we entered the resolution agreement, they did it without a teacher. It was online only. So when we asked the principal why they weren't offering these high rigor courses when they were in the other 3 high schools in the district, and the Black students in the other 3 high schools were taking and succeeding in advanced placement microeconomics, in the full panoply of advanced placement courses that were available to kids in the other 3 high schools. So we asked the principal why he's not offering them, and he said, well, these kids need remediation. So again, not very coded. That principal is not the principal anymore. And that district has not only agreed to start offering advanced placement courses to those kids and to allow for dual enrollment for them in community college so that they can take courses if they're not offered at their high school, but they've also agreed to go back to kindergarten to figure out what it would take to create a pipeline of kids who are prepared for success in those courses by the time they get to high school, to communicate to the kids and to communicate to their staff. We believe in you, we're ready for you, we will educate you, and you can do this, which is amazing. And the district is finally becoming the place that they had promised a court that they would be. The South is not the only place where we do that to kids. I'm going to tell you a story about a district in California that had for their students, there was you're 4.5 times less likely to be able to be in gifted and talented courses and high rigor courses in the district if you were black than if you were white. So we entered into an agreement based on disparate impact with that district about that concern. And the very first semester after the agreement, the district agreed to open up access for 42 courses so that more kids would be able to be in them. So the resolution in this district was not to turn white kids away and to say, there's one pie, and so we're gonna take your space and give it to black kids. It was to expand the pie and say, we're gonna have more kids who are gonna have access to higher rigor courses, and those kids are taking them and they're succeeding in them and they're doing great. And the district has moved beyond just changing the entrance eligibility requirements for kids in those courses to finding ways to really support kids in them, and from doing things like offering extra tutoring to identifying capable but underperforming students who can need more support, and so that they can be kids who think of themselves as kids who will take those courses and succeed, which I'm really excited about. In the theme of time, we also were investigating English learners' access in a New Jersey school district, and we learned in the course of that access, and what we were looking at was just, do you teach your English learners? Do you appropriately recognize who is an English learner? Are you supporting them and helping to make sure that they can exit the English learner program when appropriate and move on? But what we learned in that district was that the district was busing kids to particular schools where they thought they could best serve their English learners, but the buses arrived late and left early, so the kids had less learning time than their non-English learner peers, and their teachers didn't have training to teach English learners, but they did have 10 more kids in their class than their peer teachers who were not teaching English learners. So this is a district that was, in every way possible, setting up the kids to fail and not finding ways to support them and deliver what they should, which they now do. We also find ways that districts say that they don't care about their kids. So it's not just the communication through not delivering opportunities, it's not just the communication through not giving you enough time or stacking the deck against you, but it's actually saying, we don't welcome you here. This is a Colorado school district where the district administration took the position that speaking English was a requirement, and anybody who spoke a language other than English wasn't welcome there, so that they had a policy of trying to push out staff who were speaking Spanish with their students. There was a principal in the district who said, well, don't worry about cleaning up the bathrooms and messes in the bathrooms, because Mexicans don't know how to do that. And a kid, an elementary school student, fell on the playground, got a gash on his head, and he's a monolingual Spanish speaker, and he's 5. And he went to tell the teacher who was monitoring the playground that he was bleeding and he needed help, and she didn't understand him. And so she wouldn't give him help. And it wasn't until an hour later, when he got to a teacher who did speak Spanish, who could understand what he said, where he got the medical attention that he needed. That district has a new superintendent who is a bilingual Spanish speaker and who has created, as part of the remedy, has created a bilingual parents community that he meets with in Spanish to make sure that parents understand that they're welcomed, that this is a district that will serve them and their children. And they are making incredible strides forward, including in terms of academic progress, which is, I think, very, very exciting. Lest you think that the kinds of discrimination that I described take place on the dimensions of race and sex only, and that we have hit the mountaintop for our students with disabilities, I want to tell you just a few stories about our resolution agreements with respect to disabilities also. So just last summer, we entered into a resolution agreement with a college that had admitted a student with cerebral palsy, and then he went, just before school was to start, to talk about what services he was going to need, what services his social worker would provide, and what he still needed from the school. And so the school rescinded his admission. And we thought, well, okay, that's a pretty flagrant violation of the law, so perhaps there was something that we misunderstood. And so in the course of our investigation, the school said, oh, well, what we usually do is we take a look at the IEP, the Individualized Education Plan for a student who's applied, and if we don't think we can serve the student, we just don't let the student in. So it got worse in the course of the investigation. And so that student is now at that college. They are now fully serving him. That college has entered into an agreement that has all the kinds of things that you would expect, and they have to show us everybody that they reject for the next 2 years and have us evaluate whether that was appropriate or not to reject them, to make sure that they are not discriminating on the basis of disability going forward. And that doesn't take place only in our institutions of higher education. We also entered into a resolution agreement with a charter school in Colorado about a little boy who was going to start kindergarten at his dream school, and his family felt like they won the lottery and they were going to get to send him to this place that was everything that they wanted for him at school. So he and his dad went to visit the school, and on their orientation day, and the school administrator saw that he had physical difficulty sitting down and then standing back up, and physical difficulty with the stairs. So they sent a note to his parents saying, we only serve mild disabilities. Again, very unlawful, just to be really clear. Things not to do, but we only serve mild disabilities. And when his parents went to find out what they meant by that and what they felt like would be an impediment to serving this little boy, they said, well, there's a 5-inch drop down to the playground, and we're not sure we can get him down that 5-inch drop, because evidently they hadn't heard of ramps. And the classroom for kindergarten was on the 2nd floor. And so they'd have to assign a staff member to ride the elevator with him so that he could get safely to the 2nd floor every day to go to class. Or they could put the kindergarten class on the 1st floor so he would be able to get there, which they now do. So they are clear about their need to serve students with disabilities. But it's not only the kind of astonishing, we're not going to serve you forms of discrimination for students with physical disabilities, but there's a Georgia school district we entered into a resolution agreement that with it had as much as said students with disabilities need not apply and assign. They had their college preparatory program, advancement by individual determination. They just said they don't let any students with any kind of disability into. Not related to cognition, not related to anything, we just don't let in students with disabilities. So now they do, and they let in anybody with any disability of any type without any prerequisite, because that's the right way to serve all of your students. So those are the kinds of things that we are seeing in the enforcement work that we do, and the kinds of things that we're trying to call out. And as much as I am thrilled about and proud about those resolution agreements, and I know that they don't touch every kid who needs us. They don't reach every place we need to reach. And so we need to think about what more we can do. We have 49 million public school students in 97,000 schools and 16,500 school districts around the country. And we have nearly 18 million students in more than 7,000 colleges and universities. So that's a lot of need, and it's a lot of students whose civil rights can be violated. That volume of need presents an enormous challenge for us in government. And one response to that enormous challenge could be to constrict our resources and to say, we'll pick 1 or 2 or 3 priorities, go after those because we can make a difference, at least in those areas, and use our time to try to move the needle that way. That's certainly what every advisor told me to do 2 years ago when I was coming to government. Said, pick your area, find what you can do, and make a difference there. And that's, I get it. I get why people say that. It's a behemoth problem. It seems to be intractable, and it is hard to imagine serving all the kids who need us as well as they deserve to be served. But I say no to doing that. I don't think that's an appropriate response from government. Every mother's daughter is precious and deserves to be treated like the valuable learner she is. I think government has to live up to its charge, and our regulatory charge is, quote, to enforce civil rights, quote, whenever information indicates a possible failure to comply. So if we pick 1 or 2 or 3 priorities, we will be looking in the face of somebody's baby and saying, you don't count for us. You are not the issue that we're serving this year. And I can't live with myself if we do that. Our job is to enforce the simple justice that President Kennedy promised, period. So that means we have to think about what it means to do enough for the kids who rely on us, and how we can get to having our arms around the problem with our meager staff, because your dean is correct that as much as we have seen an incredible mushroom in the volume of complaints that have come to us, we have seen a constriction in our staff, so that we are now at a historic all-time high in complaints and an historic all-time low in staff available to process those complaints. Whereas in prior years, my staff used to carry 6 or 7 cases per person, they now carry 26 cases per person, and it's a crushing caseload. It's very, very hard to meet that volume of need well. So the buckets that I put what we do in are that we need to be more transparent, more comprehensive, more forceful, and more supportive. And I'll tell you a little bit about each of those. On transparency, we have, since the dawn of our agency, been collecting data about the equity health in our public schools. And that means that we are looking at how our English learners are served, rates of school discipline, rates of teacher and student absenteeism, a variety of equity health indicators. We used to keep that data for ourselves and use it to think about where we want to enforce and where we're going to go to open investigations. We now in this administration make that external facing as well as internal, so that anybody's mom, any school policymaker, any educator, any community member can get that data from www.ocrdata.ed.gov, I say in a shameless plug for your use of that data as well, can get that data and can disaggregate it by gender, by disability status, by race, to see how kids are being served, and then determine whether something ought to get looked at, whether there's advocacy that should be done, whether there's something that a district or a state or a school may want to examine about the ways that it's delivering education for students. We have seen just transformative responsiveness to making that data externally facing. The school discipline issue that I've talked about, we've known since the dawn of time that we are disciplining our students of color more than our white students. But this last year was the very first time that we collected data about rates of access to public preschool. And so we saw in that data that our black students are 18% of public preschool students, but they're fully 42% of students who are suspended or expelled once from preschool, which is jaw-dropping. And we made that data public, and before I've had a chance to do any enforcement work related to preschool students, we've already seen school districts saying, okay, we're just not gonna discipline our preschool students, sometimes as many as are up to 2nd grade anymore. We've taken a look at that data and we think we need to have a moratorium on it because it's just, that raises too many concerns for us. We're not gonna keep doing it. So it's very exciting to see places like Seattle and like Chicago saying that data alone is enough to make us think we need to change our practice, at least examine it to figure out what we're gonna do. So we have concrete evidence that transparency matters, that sharing just what we know happens in schools matters. So we also are very aggressive about putting out dear colleague letters and guidance to say this is what the law is. We want to be transparent about the way that we would enforce if we were coming and looking at your state or your school district or your university. This is what the law is. This is how we would apply facts to particular patterns. We want to have sunshine on what we understand our job to be and what we understand your job to be so that you can try to comply with it. And so we've put out guidance on an incredibly wide range of topics that goes from measles to English learners to Ebola, to Title IX coordinators, to correctional education, to resource equity, to bullying of students with disabilities, and on and on. So we are really trying to use that guidance in a way that is transparent, that shares what we expect, and gets our message out. Sometimes I hear concern about our authority to issue the guidance we do, so I want to be really clear that our guidance does not make new law, period. Full stop. What our guidance does is make transparent what we do. What our guidance does is to share information about what the law already is, as received from Congress, as interpreted by courts, so that we can then say this is how we would apply that law to these facts. We also publicize our resolution agreement letters in a way that we never did before now. So when I came to office 2 years ago, we had about 100 total resolution agreements on our website that people could find, and they were exemplars. We now have a default that we will publish virtually any resolution agreement that we enter into. The exception, the virtual, is for a district where the privacy concerns are just too strong, and we would absolutely be able to identify somebody, so we don't do it. But it's a tiny subset of our resolution agreements that we don't actually put online. So now there are more than 800 resolution agreements in a 2-year period that publicize the way that we apply the law to particular facts and what changes we have seen promised from districts and universities. We also publicize our pending investigations as a transparency tool. So the public now has access to lists of schools that are under investigation for any topic that we investigate. And that was an extremely hard decision for me to make, that we should make that list public. I am sufficiently pointy a lawyer that I started thinking, well, what we say when we're done with an investigation is much more interesting than the fact that we are investigating. And so we should just make transparent the end result of our agreements. But some of my colleagues in government pointed out that this administration values transparency, and that people have a right to know what the government does, and that there actually is an efficiency value for us because we might have fewer FOIA requests if people could see those lists. And so there were some benefits as against the many, many negatives that the school community has been very clear about communicating to me about the decision to post a list. I have been in conversation, for example, with a university president who all but told me I am going to go to hell because we now post our list of, he had a clerical collar on when he said it, because we now post our list of schools that are under investigation for sexual violence because it was such a wrong decision. But also student activists were clear with us that that's what they wanted, that they thought the list would be meaningful. So we did some soul searching, I did some soul searching, and we ultimately made the decision that they were right and that the transparency value was enough of a value to make it right, to increase awareness about what it is we're investigating across all of our areas, and to encourage schools to take action because that list itself would become transparent. And I believe it has made kids safer. I believe it has been a reason that we have expanded the public conversation that we have about the work that we do and why we do it and how we do it. So I think it was the right call, even though it was a very hard call for me to make. We also are significantly more comprehensive about the way that we do our work. And that's hard for us to do, especially with our diminished staff. But we now, if a complaint comes to us, it was, until a few years ago, it was that we would investigate the four corners of what was in that complaint. So the investigation was bound by the magic words that often uncounseled complainants thought to say to us about what they thought the scope of an issue was. We now issue spot for ourselves. We use our own expertise. We take a look at what is in the four corners of the complaint, and we see if that means that we should be looking at things that maybe the complainant didn't know to say, but that also are within our jurisdiction that we should investigate. So it takes us a bit longer to do those investigations, but we are more able to take a look at what it looks like to violate a student's rights, and we are more able to take a look at what might be necessary to remedy those violations where they exist. We are also more forceful, as I mentioned. In the last few decades, we didn't, as an agency, prioritize acting to enforce or even very consistently state that we might act to enforce the civil rights of students, and that's pretty far from true now. I have said over and over and confirmed by beginning the process to enforcement several times in my 2 years here that I mean it, and we will take your federal funds if you won't protect your students' civil rights. We also now set an endpoint to our negotiations so that we won't have an investigation just drawn ad nauseum. So once we have communicated a violation to a university or to a school district or to a state and said, this is what we see as wrong with what you have done, that entity then has 90 days to enter into a resolution agreement with us, or we begin our process to withdraw federal funds or to enforce. So that hard stop is one way that we are able to move forward with some places that had some difficulty with taking seriously the requirements that they have and our ability to enforce them. At the same time that we are more forceful, we also are working to be more supportive, both of the recipient community, the school community, and also of our own people. It's an enormously challenging time to be doing this more comprehensive work with all of these complaints and changed ways that we do it with people, many of whom had been here over a long period of time doing things another way. So we are trying to be very clear about what we expect for our staff and externally. We're trying to make sure that people have the training that they need to be able to do that work well and to actually have the expertise to be able to investigate and evaluate. And we have placed a real premium on self-reflection. Each time we enter into an agreement, what could we have done better? What could we have done differently? What more could we do next time, so that we're not just stamping out the same disease over and over, but we are finding ways to disincentivize its recurrence in another place. So I'm pretty excited about those tools. I think we are becoming the agency of dreams. I think we are doing the work the way that a vibrant civil rights agency should be doing the work. I think we are living up to what has been now for 50 years, a national consensus about the value of civil rights. We have seen a dramatic diminution in the available legal tools available to us, but we have not gone back on the civil rights laws that Congress has promised for our students. And the promise that I grew up with is the promise that I expect my daughters to grow up with, and I hope their daughters thereafter. So we are enjoying what that means, even though we also find it challenging to live with that diminution as well. For myself, having watched what is halting struggle forward, sideways, backwards, sometimes forward again, I think we have the information now to know that the pull to discriminate is strong, and if given a chance, too many people will take it, and that the opportunities for discrimination are legion, so we need to anticipate and we need to obviate the need for their doing it. I think Thomas Jefferson was right all those years ago when he said that the price of liberty is eternal vigilance, and I am prepared to be eternally vigilant. I also share civil rights activist Ella Baker's update to that sentiment when she famously said, "We who believe in freedom cannot rest." And you are welcome that I'm not going to sing the Sweet Honey in the Rock version of that for you. But I do want you to know that I am not sleeping on your rights in my office. And we don't assume in the Office for Civil Rights that the problem of discrimination is solved. We are carrying our civil rights mantle forward, knowing that we need commitment to eternal vigilance, belief that we can do better, and an insistence on better, not only for the people that we love and that we know the most in the world, but for the people whom we don't know. Because even though the work is hard and it's not linear, it's our charge, and we love it, and we're prepared to do it, and I'm looking forward to being in conversation with you about what that looks like. Thanks very much for having me.
Sweetheart. Michelle, I think we have to do your singing.
Thanks.
That's called self-identification.
I need it.
Thank you, Madam Secretary. It's wonderful to have you here, and we're so proud of you at Yale Law School for the work that you're doing. that is very important to the future of the country and the protection of our people. I've had too many years in Washington not to ask you this particular question, and that is, you are part of a statutory arrangement that involves, my last count, is probably 15 different organizations, committees, departments, and so forth. And I just wonder how all of that is coordinated in a way that benefits the objectives that your agency is established to achieve. I'm particularly concerned about this because, as I understand it, your organization has the ability to suspend federal funding to those who are being investigated until they comply with the standards that you've set out to comply with their violations or prospective violations of federal law or policy. Could you clarify that a bit? Because I know enough about the wars in Washington and how many scars I have doing that this is not an easy thing to accomplish. But the group that's involved with your particular role is larger than any I had to confront with during the time that I've been in Washington. So could you give us perhaps a clearer picture of how this coordination operates and is not a barrier to what you're trying to accomplish, but really facilitates your achieving the ends that you're there to achieve?
So I'm at the risk of making you jealous. We have a more streamlined process than you did for this particular purpose. So I am the advisor to the Secretary with respect to civil rights laws, and we don't need to get permission external to our office. We have our own lawyers about what our steps are for enforcing federal civil rights. And so while there is tremendous bureaucracy in government in general, and I live with that, on the question of moving toward enforcement for us, I make that decision for our office, and the checks on that are that we either refer it to the Department of Justice to litigate. I don't litigate for myself, or if we keep it and we move through administrative enforcement, then an administrative law judge holds a mini trial and determines whether what we did was appropriate or not. And if either way, then there's an appeal process that then can go to court, but those are the checks and not an internal bureaucratic set of checks. The Office for Civil Rights makes its decisions about what the law enforcement terms are without having to go through as many as 15 other elements within the building.
But what about the suspension of funds?
That's a
Is it
suspension of
your
funds.
determination
Yes.
to make? And so,
I mean, the administrative law judge has to agree with me if we get there, but
fine. Yeah.
after a trial, right?
Okay. Thanks very much.
Sure.
So one of the most wonderful things about going to law school here was, which feels very different in this day and age, is the sense that government could be used to affect social change. The sense that the government was a force for good, which we don't see as much in the debates today. It's sort of related to Drew's question. We see the Equal Employment Opportunity Commission, which is completely paralyzed, and their decisions are frequently challenged in court. They are defunded. National Labor Relations Board is a government adjudicatory board, which we've seen their power be diminished. Should your agency be a model? Well, let me add one piece of that. And I saw the courts totally fail to affect civil rights enforcement, with something like 70 and in some courts 90% of civil rights cases being dismissed without ever getting to a trial. So we see other mechanisms of enforcement of other parts of the discrimination laws really not live up to the promise that we felt they had. Is your agency a model? Is there some way that your agency could be a model for the enforcement of Title VII, not in a university context, but in an employment context? Or is the short answer to that two short answers? One, you are fabulous, and two, you can defund. And as long as we don't have that, nobody else will ever be able to affect this.
Well, I certainly like that short answer, but we'll we'll put that one aside. I think our model works. I like our model. Let me say, I think our model works when it works. I think that I have concern about it when it hasn't, and that's one of the many insights of Professor Day's scholarship that I carry with me every day about the need to take the mantle that I've been given and absolutely run with it, because we don't know how long we're going to continue to be this aggressive in the celebration of the ability to take these promises and make them lived in the backpacks of our students in schools. But my friends who are commissioners on the EEOC, I think, would not feel like they are not able to succeed in what they're doing now. Also, I think that they have seen revitalization in this administration as well, and I've been pretty excited about the kinds of decisions that I've seen come out for them. It's a very slow process. It's often a slow process because what precedes getting to EEOC can take a long time, and that's a concern. I don't know very many complainants who feel like coming to OCR is a really lightning speedy process either, and also, what you're able to bring to OCR is not the initial harm, but the failure of an appropriate response that led to an ability to come to us, and so that's also a slow process. So I think there are ways in which what we are doing is a model, and I love it, and I'm really excited about it, and I think there's ways in which one could take what we're doing and think about whether there are elements of it that can work someplace else within their existing constructs as well.
Michelle?
Sure. So, so much to talk about here. One question I have has to do with the disproportionate preeminence in the popular imagination of sexual violence that your, as if your office works almost exclusively on that issue, and you sort of correcting the record and saying, look, it's about 10% of our work. And I also am wondering what it's like to be criticized by liberals, progressives, and leftists on that issue in ways that you're just not with other civil rights issues. I think that's true for gender-based violence. Moves to change the nature of women and men around issues of gender-based violence often draw fire from not just conservative opponents to civil rights, but they draw fire from the left as well. And I wonder what that does to the folks on the team at home, and what that does to you and how you think about that and how you process the criticism that you get, not just from folks who are traditionally conservative and resistant to ideas of civil rights, but from those who believe that the criticism of you and what your office is doing comes from the perspective of civil rights.
Yeah. So I wish that we only saw that criticism with respect to sexual violence or even sex discrimination. I am very often criticized for very much of what we do, so from all corners. And
point taken.
Yeah.
I guess it's just also a question of kind of disproportionate hearing noise that we hear, and what gets kind of the popular limelight.
Yeah, no, that's right, and I'm delighted when people don't know about the criticism too, so that's fine. But the way that I address it for myself is that A, I've never done anything that I wasn't criticized for, so it's familiar to me. B, I think that means people care, and they're talking about the issues that we're working on and that they matter to them, and so that's important. And C, in every criticism, there is the potential for something that we should be doing differently, and something that is that we can own in the self-reflection process that we have to think about whether we're doing enough, whether we went too far, whether something was harmful, whether we didn't balance competing values appropriately, and that's important to think about every time. I mean, we will not have a corner on the market of the ways to discriminate, and we can't. So we have to be thinking about that, and we have to think about how we most disappoint our friends, as well as how we most disappoint the people who were opposed to what we were doing in the first place. And if we're most disappointing the people who were opposed to what we were doing in the first place, I want to make sure we're doing it right. We're really disappointing them for the right things. And for the people who were predisposed to like what we're trying to do, but feel like we did it all wrong, I want to think about whether they're right and whether we ought to do it differently the next time, because It's somebody's kid who's in school, who's trying to learn, which is a core value, which is the difference between economic security, is the difference between civic engagement and not. It is the difference between growing up sometimes and not. So I think we really have to think about how to do that right. And that's what I learned here. It's what I love the most in the world. It's what I'm happy to do. And so I don't always relish doing it in a public space, but I feel like that's part of the job. So, okay. And so then on your question, so that's my answer for me. How does it feel to my staff? It doesn't feel that great. Let me just say as the short version. The 600 people I have the privilege to lead have many of them been there well before I came and expect to be there well after I leave, and not all of them are super comfortable with being an agency that is as much in the public eye as we are now. Not all of them are delighted with the decisions I'm making about the way that we do things, and many of them voice internal discontent as well. And I think that's good for us. I think it's good for us to engage in that conversation, to think about where would be the straw that would break our camel's back. What is wrong with what we're doing? I mentioned that the decision about whether and how to release the lists of whom we're investigating was hard. That was internally really hard. I mean, it was hard in the way that people had to go and close their doors because they were so upset and they didn't feel like they could talk to people. After some of the debates that we had about it, it was hard. And then our staff were saying complainants will stop coming to us if they know that their story will be told publicly, and we will turn people away that we need to be serving, and that's a bad idea. That's harmful for our work. There were people who said, we will lose our neutrality. We will lose our perceived neutrality, and so that will be bad for our ability to do our work if we do that. There were people who said we've never done it this way. We haven't told people that this is going to happen, and so that's bad for us. I mean, it was just a very, very hard conversation. We have hard debates like that on most of the work that we do on, is this the right outcome in this case? Is this the right way to process this case? Is this the right way to be doing our work now? Because we used to do it this other way, and we liked it. And so, I think dissensus is important. I think that's how you get to the right answer. I think that's the best civil rights work. That's the way to do it. And that is uncomfortable for some people. And I'm sorry that that's uncomfortable. And so I try to work with them to help them to greater comfort, as much as I also think it's right for us to do.
How do you see the civil justice system fitting into the paradigm that includes your agency?
So, I'm a believer in having lots of forum for us to go to for relief, and I think, I'm happy to be the arm of government that can do some things that private litigants can't. So we have disparate impact that we can still enforce. Private litigants can't. That's a charge I take very seriously. We got to use it because nobody else can. So we got to make sure that we are there in that part. There are quite a few people who can come to us who would have no chance to go to court because they couldn't get a lawyer to represent them because their claims don't have dollar value that would make it worthwhile for a lawyer to take that claim on. There are people who don't really know how to fight. I mean, we have essentially pro se litigants who come to us, right? I mean, that they call us and tell us what bugged them, and then we figure out whether there's a there and how to investigate it. And I love being the place that doesn't turn anybody away. As long as we have jurisdiction, as long as it took place in a school, it falls within the scope of the laws that we enforce, and it was relatively recent in its occurrence, we'll open your complaint for investigation. There's no place else but government for that. So I love being that tool, and I'm delighted to be that tool in parallel with the active litigation and the active use of other processes. I'm delighted when a complaint doesn't need to come to me because the school is resolving it appropriately in the first instance. I'm delighted when there are serious issues that we see coming up on campuses that our campuses address for themselves. And so people then don't need to get to the place where they've got to seek relief from us. I think that's government working at its best, and that's success. But where somebody does need to come to us, I'm happy to be my cog in the wheel too.
Now, we have talked about this, Catherine, before, but there certainly is has been charges of an overreaction at some campuses. An overreaction in anticipating very interesting sort of synergy between your inviting complaints and the demonstrations that took place, and the significance of schools not wanting to be listed on your webpage led to certain schools to go further, arguably, than they should have in complying, which led to lawsuits and a number of court decisions allowing, not on the merits, but allowing challenges to various Title IX procedures to go forward. and the footnote to that we've talked about is I was one of the Harvard Law School faculty that reacted to the Harvard University policy, which went further than the government ever wanted them to go. How do you deal with the overreaction on campuses all across the country? The overreaction meaning the overreaction that is more complainant protective than rights protective, than defendant rights protective. How do you deal with that?
So
We're talking about the civil justice system
Just
being
right.
folded in, yeah.
Yeah. I mean, for me, a civil rights violation is a civil rights violation. So if you are not providing due process, you school are not providing due process for all people who will be part of this process, you violated the law, and we've got to say that. And we've at no point not tried to make that clear. When we've started to see that there are places that are going the wrong direction on either side of that, we try to be clearer about it. We put out more guidance, we give more speeches, we say it more, we say it in our resolution agreements, we call out attention to it. It's one of the reasons that I call out attention to our two most resolution agreements on that topic today, because it bugs me when I see places that are going the wrong direction on any facet of what the wrong direction is. And as I know you know, we said that the Harvard Law School policy was non-compliant with Title IX, the one that you were concerned about. We also were concerned about it. We hadn't gotten to finish yet at that time, but it's, as soon as we were done and could say it, we said it. And the concern for me is when there's any form of discrimination that falls within our jurisdiction, we need to be prepared to speak to that. We need to be prepared to be clear about it, and we need to try to incent compliance in general. So we want to make sure our schools know what the law is and how to satisfy it, so that they're not wondering, they're not thinking, well, this is what you wanted. They're clear, this is actually what we should be doing. So we try to get that message out, and I think that we will always be playing catch up, because there will always be probably infinite ways that somebody could misunderstand what it is that the law is. But that's why there are courts, that's why we exist, and we try to be as clear as we can about it.
Michelle?
So I'm interested in, I guess, what I'll call sexual assault exceptionalism, both in terms of the disproportionate public airtime that work that your office consumes, and also in terms of the reaction by, in particular, members of the Legal Academy who are very concerned suddenly about the due process rights of those accused of sexual assault, setting apart entirely the question of overreach and inappropriate procedures imposed by campuses. The preponderance of the evidence standard is one example. So historically, as you know, about 80% of campuses had no standard of proof in their adjudicatory process. And of those 20% that had a standard of proof, the vast majority, again, 80% used preponderance of the evidence. And interestingly, it was the Ivies that fell into the beyond a reasonable doubt standard of proof. And yet suddenly there's a real move when sexual assault comes into scrutiny, that and when process around questions of due process around sexual assault come to the fore, that there's a real call for a need for enhanced due process when the claim is sexual assault. And that in those instances, there needs to be a beyond a reasonable doubt standard, or that somehow in those instances, the rights of confrontation are particularly acute, or in those instances, as opposed to any other, since the early part of the 19th century, campuses have been adjudicating disciplinary violations. And I guess I wonder if in formulating the Dear Colleague letter or the Q&A, or thinking about how a campus responds to sexual assault claims, if there's a concern for singling out sexual assault for and claims of sexual assault and process around sexual assault for additional process for the accused or additional concerns for the victim.
Yes. Yes, there is concern. I have jurisdiction over sexual violence and sex discrimination. I don't over everything else that schools can include within their sexual misconduct policies and their misconduct policies, their student conduct. And so if I were queen, which would be nice, but if I were queen, then I would require a process, fair process for everybody on every issue. What we know is most schools use a similar process. Before 2011, when we put out the Dear Colleague letter specifying the preponderance of the evidence standard, most schools, as Michelle said, that specified a process at all, specified preponderance of the evidence, but also most schools were using preponderance of the evidence, period. And the study that you're talking about was from 2001. There was a 2011 study, which is actually done by a group that hates us and what we do, that said that most schools actually were using the preponderance of the evidence standard. I guess I want to concretize what that means school conduct board are looking at with respect to preponderance of the evidence. I mean, they're looking at simple assault in addition, so not sexual assault, but assault itself. They're looking at arson. They're looking at plagiarism. They're looking at theft. They're looking at pretty serious issues that often also have criminal law analogs. And they're reviewing those through preponderance of the evidence standard because it is the fair standard. It is actually what the courts have said over and over again in a civil context is the right standard to use for the civil analog to murder, is the civil analog to rape, the civil analog to any of a number of crimes. And so it's not news, it's not a surprise. It is, I think, surprising that for the sexual violence exceptionalism point. I think that many of our campus faculties hadn't been thinking about what their student misconduct boards were looking at, period, and hadn't been thinking about how we should be evaluating assault or not, how we should be evaluating arson or drug sale on our campuses or not. I think if my kid were attacked at school, not sexually attacked, but attacked at school, I'd like the school to have a fair process for my kid and for the person that my kid is accusing also. And I'd like the school to be involved. And so I think we are decades past the time when we said, in 1975, that schools should be involved, decades past the time when the courts first said that schools should be involved, which was in 1991 in the Supreme Court. And so well past the time we should have been thinking about this question, about how it is that our schools should be investigating. And the use of the preponderance of the evidence standard isn't a surprise to anybody who's been doing this work. It's what we were doing in the Bush administration. We just didn't tell anybody because we didn't put it in guidance, but the schools that we enforced knew, and they didn't love it, that their peers didn't know. So, we were trying to be more transparent and share that information so more people knew, but it wasn't a new thing that we were doing. It's what we had been doing all along. And it is also the ways that most schools, absent our intervention, also were doing it because it's what the courts say to do. So it's that particular upset about it, and it feels like it's so unfair and it's really hard. That feels to me like a tempest in a teapot because it's a decision that has long since already been made, well before we came to say it out loud. It is, as I mentioned, what we were doing well before this administration, and it is also what the courts have said to do. So it is, it's news because it's news, but not because it's new to us.
Well, I think we ought to open this up to questions, but I didn't want to leave you alone before you gave us some sense of your interpretation of the events in Illinois and in Houston, a suburb of Chicago, and Houston, about sexual identity. Could you give us a sense of where you think that is going, what it represents, and the status of those types of protections of civil rights?
Yeah, so Houston is just passed an ordinance that takes out gender identity protection that had already existed for Houston, which is not what I would have voted for, shall we say. I have the luxury of knowing that we still have Title IX and federal law will trump with respect to the schools that are in Houston, which is good to know. I feel very, very confident about our interpretation of sex discrimination and what it is that Title IX covers. I will say in this room that when I was a student here, I wrote a paper about transgender person's rights with respect to employment. And I was talking about what I thought was a new and challenging area of law with Brooke Marshall, who I said was my hero, and who wrote the 1964 Civil Rights Act, which I also said and is relevant here, and was saying, it's hard to figure out how the court should interpret this for purposes of Title VII, and I feel like it's a really new issue. And he laughed at me. And he said, it's not a new issue. Of course sex discrimination covers that. What are you talking about? And I love him for that. And I think also, he wrote it, he knew what he was talking about, so we got to really make sure that we live up to it. And it would be nice to bring both the voting populace along and also the rest of our courts, because we're ready. Our kids need it.
Okay, let's open it up for questions.